Grab a drink and settle in. Welcome to the Wills and Spills podcast, where we sip cocktails and unpack the most fascinating estate disputes behind the court judgments. The podcast is about real people, real family disputes, and the wills that have sparked them. Now, to help me spill the story behind our next case, I have Nicholas Baum. Now, Nick is a barrister practicing in commercial law, public law, and equity and trusts. He's been recognised in the Doyers Guide list of leading wills and estates litigation barristers in Victoria. Welcome, Nick.
Thanks, Linda.
Thank you. So tell us what case we're unpacking today.
So thanks for having me. Today, the case we're talking about is Wielicki and Millar. It's a decision of the Supreme Court of Victoria decided in January of this year. It was a Part 4 claim or a testator's family maintenance claim, which is a claim for provision from someone's estate. It was brought by the wife of the deceased who had died. And what's really interesting about it is that it was disposed of by summary judgment rather than going to trial. And that's something we're going to talk about today.
All right, before we get into the case, I want to provide a brief summary of the background for our viewers. So the deceased was survived by his wife, Michelle, and his adult daughter from a previous marriage. The deceased left a will appointing his daughter as executor. Under the terms of the will, the estate passes to a testamentary trust and his daughter is the primary beneficiary. No provision was made for Michelle. The gross value of his estate was 1.9 mil. So Michelle filed an application in the Supreme Court of Victoria seeking an order for provision from his estate. Now, these claims are often referred to as Part 4 claims or testator or family maintenance claims. But for the purpose of our discussion, I'll refer to them as Part 4 claims. So the deceased daughter, in her capacity as executor, filed a summons seeking a summary judgment on the grounds that Michelle's Part 4 claim had no real prospect of success. Nick, can you please explain what is a summary judgment?
I think it's important, Linda, for the viewers to understand that normally the process of bringing a proceeding and getting a matter to trial is a very slow process. It can be 18 months or 2 years from when you bring the application to when there's a trial. And that's slow and frustrating for litigants. Summary judgment is a process which you can apply for, which deals with the claim much more quickly and gets rid of it without there being a trial. And so in this case, if you're the person who's been sued, that's something that you'd want. Now, getting rid of a matter without a trial is a really serious thing. People who bring a claim have a right to have their matter heard. And so the court will only get rid of a matter without a trial if the court is satisfied that the claim has no real prospects of success. And that's what the deceased daughter was seeking here. She was seeking to get rid of the claim without having to wait all the way till the trial.
Yep. I want to expand on the purpose of Part 4 claims as we deal with these sort of claims on a regular basis. The purpose really of bringing a Part 4 claim is to allow the court to intervene in the distribution of the deceased estate, where it's under a will or under a testacy, fails to make adequate provision for an eligible person. Now, we know eligible people include spouses, domestic partners, children, certain dependents, and members of a household. Now, in this case, Michelle was eligible to bring a claim because she was the wife of the deceased. But what the court had to determine was whether the deceased had a moral duty to make proper provision for Michelle, and if so, whether the will failed to make adequate provision for Michelle's proper maintenance and support. Nick, what did the courts have to say about this?
The court looked at the test, and the test has been established in a number of cases, requires you to consider, firstly, is the person who's applied eligible? And there's a list of categories and someone's spouse is eligible, so they were eligible. The court has to look at whether or not the deceased had a moral duty to make adequate provision for that person, and that's a phrase we'll come back to. If they did have a moral duty, the court has to look at whether there was adequate provision, and if there was not adequate provision, the court goes on to consider, should the court order provision, and if so, how much? In this case, the court said, well, here the moral duty to provide for the deceased wife, Michelle, was satisfied. Yep. The associate judge found her care for the deceased made the deceased life enjoyable, prolonged and comfortable. That was a slightly odd thing for the judge to say because whether or not someone has a moral duty to provide In this case, the judge went on to say, well, there's no need to provide, and so it's a bit contradictory, but we'll put that to one side. But in any event, even if there is a moral duty, as the judge said here, that's not the end of the story. You have to look at, has adequate provision been made for the person's proper maintenance and support? And there's a list of factors the court has to have regard to when considering that. The one of the critical ones is questions about the financial resources, the earning capacity and the financial needs of the person who's bringing the claim. And that was the critical question in this case.
One of the other factors also I know the court takes into consideration or may take into consideration is the relationship that the person had with the deceased. I want to talk a little bit about that now. So in support of Michelle's Part 4 claim, she filed 2 affidavits and a written submission. She says that they've been married for over 19 years. He worked as a development manager. She was a doctor. She described their relationship as being wonderful and loving. During the marriage, the deceased experienced ongoing health issues. In 2009, he had a stroke, which left him being able to speak and had really poor balance. Now, he underwent some rehab and eventually Michelle stopped work to care for him, but he did get better to the point that they could go on another holiday. So Michelle went back to work, but with reduced hours. But unfortunately, he got worse, his health deteriorated, and so she had to give up her work entirely and she became his full-time carer. Now, in Michelle's affidavit, she does go on to say that she was hurt when she found out the deceased had excluded her from his will because she regarded their relationship as being great and she'd sacrificed so much to look after the deceased during their marriage. Nick, as we mentioned earlier, we do lots of these Part 4 claims, and often claims are brought from a place of hurt or neglect or even on principle. What's the court's view about this?
I think the human story here is genuinely moving.
Yep.
It's worth pausing and thinking about that before thinking about what the court does. This is someone who gave 2 decades of her life to her partner, and the judge recognised that. The judge did not brush over that. That evidence was there. The judge accepted that she'd done that. It was not just a throwaway thing. The court wasn't unsympathetic to that, but sympathy with her position and her legal entitlement to make a claim are 2 very different things. There's consistent authorities in the court that the court's role is not just to reward meritorious conduct. It's not to compensate people for past services. Yep. As we've talked about, the test is very specific. It's about adequate provision for proper maintenance and support. And so if the plaintiff can provide for herself, it doesn't matter how she's treated her partner in the eyes of the law. It is going to matter to a degree in the line ball cases, but it's not going to be enough on its own.
Yeah, look, it is sad, isn't it? Well, you've cared for your partner for over 20 years. You read his will, he's left you out of the will. I mean, I would be pretty hurt by that.
Yeah.
So I can understand why she's like, well, hang on a minute, what about me?
And I think, and this is something we both would have said to clients, Linda, but the word fair doesn't appear anywhere in this legislation.
Yeah.
And the first thing clients say to you when they come through the door is, this isn't fair.
Yep.
And it's a really hard message to tell clients, and I'm sure will be a hard message to deliver in this case, to say, look, it's not fair, but the court can't help you with that. But that's one of the important messages.
That's right. And it's not enough to, and like I said, people do come to you because they're hurt. Mum left me out of the will. My partner left me out of the will. I'm really hurt by this. Again, that's not a proper basis to bring a claim because it's come from a place of hurt. Yes. Even though that's sad, I can empathise with a lot of my clients, but it's not a proper basis, unfortunately.
These cases ultimately are about money. No one gets closure out of one of these cases. No one brings a Part 4 claim and feels better about what's happened. The will is still going to be the will.
Yeah.
And so these cases are ultimately about money. How much money does the person need and how much money is the court going to give them?
That's right. I want to discuss the daughter's submissions to the court. Now, the daughter accepted Michelle was an eligible person to bring a claim, so that's not in dispute. But what she argued was that Michelle had no real prospect of success because she had failed to demonstrate any financial need or any need really. So in her submission, she relies on quite a few authorities to support this proposition. The financial need is essential in these Part 4 claims. Can you take us through the cases she referred to and what constitutes need?
So I think there is a very consistent line of authority that the judge referred to, saying need is a necessary part of this claim, and it's financial need. Fanning and Harding in 2013 talks about being a threshold issue. Jones and Smith in 2016 says something similar. But when we talk about need means different things to different people. McEwen, Shaw and Shaw in 2003, the court explained need is a relative concept. A larger estate can afford more and can have regard to different needs. A smaller estate, that's harder. Unger and Sanchez in 2009, Justice Kay explained there's a connection between the moral claims. So a plaintiff who is in great financial need may succeed in their claim even if their relationship with the person who died is quite poor. A plaintiff who is in less need, has some needs but less need, but had a very good relationship with the deceased, is also likely to succeed. And so the concepts are connected, and need is informed by the circumstances. And the authorities are also very clear that need does not mean that the person needs to be destitute or totally without resources or in dire economic straits. Need is something more comfortable than that. My favourite expression, one that gets cited a lot in this area, is from a 1960s decision, Bloor and Lang, where the court said the need of the plaintiff was not for the bread and butter of life, but for a little of the cheese and jam.
I love it. Yeah.
Now, I know that's very old-fashioned language, but it does embrace the concept that for some people, bread and butter might be need, but for others, need might mean something else.
Oh, what about Dom Perignon and caviar? That would be my need.
I'm yet to see a case where that succeeded, Linda, but there's always a novel one.
Well, one day. Okay, I want to talk about Michelle's financial circumstances now, right? So she describes her financial position as being stable. But let's go through what she actually has. So we mentioned already she's a doctor. She's got an earning capacity exceeding $300,000 a year. She owns 3 properties. So she's got a house in Patterson Lake, unencumbered. That's valued at approximately 2.6 mil. She's also got 2 investment properties valued collectively 3.1. She has superannuation income and savings of approximately 300,000. So in total, her asset pool is over 6 mil. In these Part 4 claims, the court will consider a person's financial circumstances. What was the court's view about Michelle's financial circumstances?
So claims by spouses are normally amongst the best kinds of claims you can bring. And what a court looks to provide a spouse, if the assets are there, is typically, do they have a roof over their head? If they don't have a roof over their head, that's a priority. Do they have a source of income? If they need to be able to invest some money to create a source of income, that's a priority. Do they have a nest egg that they can call on so that if they become sick or unwell or something tragic happens, they have resources to support them? That's something the court likes to provide. But Michelle's problem here was she has all of those things already.
Yep.
And that was
and more, right?
And more. She's in a comfortable financial position by anyone's standards. And so when the court looked at her financial position and said, what should she be provided? The answer was, well, there is no need to provide her with anything. A good rule of thumb in these kinds of cases is if your own assets substantially exceed the assets of the estate, you probably shouldn't be looking to the estate to provide for you. Now, that's not an absolute rule, but it does give you an indication that typically someone who's seeking provision is in a worse position than the pool of assets they're asking for.
Well, Michelle's barrister submitted that, okay, financial resources of a claimant is really one discretionary factor that the court can have regard to. So his argument was, well, this should not act as a bar for her to claim further provision from the state. So Michelle's barrister said that her need was established by the following. He said her relationship with the deceased, the care she provided for him all those years, and the financial professional sacrifices she made in order to care for him. Look, it was evident that Michelle became his carer and her responsibilities as a carer was substantial. Now, Michelle's barrister also submitted that by virtue of her sacrifices, that the court should order provision from the state for her proper maintenance and support. So accordingly, her barrister said that her claim had a real prospect of success. So Nick, how did the court address this, and did the sacrifices Michelle make sway the court? Like, is it a valid argument?
The sacrifices she made powerfully informed the question of moral duty. The court did not ignore them. They were relevant. But there's a clear line between the moral duty analysis and the adequate provision analysis here. The argument that was being made was because she sacrificed, therefore she was in need. And that wasn't, in the court's eyes, a valid argument. The sacrifice informed the duty, but it doesn't inform the question of what does she need. The plaintiff's argument that need isn't always confined to financial need is true. There are cases where it can mean something more than that, but it does require financial need as an element. All the cases were consistent on that, and Associate Justice Irving made some very clear statements that was a requisite part of the claim. There's a cap in one of the provisions in the legislation. This is a bit technical, I know, but Section 91, subsection 5 of the Act says that the court can't give someone more than they need for their adequate provision for their proper maintenance and support. And so the court, it doesn't have a discretion to go through this here. If someone has already got that financial comfort, then the court can't give them more than that.
And look, and I agree with you. The court emphasised that they're not empowered to rewrite the will simply because it's not fair or the wife should receive something, right? And the statutory test really is about was adequate provision provided for her proper maintenance and support in regards to her financial circumstances. And you mentioned this before, in this jurisdiction, and I have to say this to clients, it's not about fairness. I want to say it is, but it's not. It's not about fairness, and it's not about compensating someone for what they've done. Or, I've had clients say, Dad was an awful person, so therefore I want compensation. And our jurisdiction doesn't do that. Yeah.
There's a real structural constraint on judicial power here. Judges aren't given a blank slate to rewrite someone's will. This area of law starts with the proposition that people are free to write a will that they want to write. People are free to leave their money where they want to leave it. And unless you get through the statutory test that Parliament's laid down, judges can't just rewrite the will just because it is unfair, even if it's objectively unfair. It's quite interesting in this regard that those who've been in this game for a while know there were some big changes to the legislation in 2015 that really tightened up some of the parts of the legislation that some people thought were being abused. And one of the elements of that was a renewed focus on the question of financial need. It had always been there, but it was given greater emphasis. And the parliamentary debates at the time that was brought in, it's pretty clear that Parliament intended that financial self-sufficiency would ordinarily preclude being able to make one of these claims.
Yeah. Look, otherwise I would make the mockery of making a will, right? Yeah. The court is there to uphold the will. They will only intervene in circumstances where you haven't adequately been provided for.
A Part 4 claim is not a substitute for good estate planning. Yep. If people know that they are in a relationship with someone who might die because of ill health, making a plan for the future and talking about that with them is an important thing to do, because these kinds of claims will not fill that gap.
That's right. So in concluding, the court was not satisfied that this matter should proceed to a trial. Michelle's claim had no real prospect of success. Now, Michelle was an eligible person and the deceased did have a moral obligation to provide for her. However, she failed to demonstrate financial need, which is really a central part to these Part 4 claims. So the court granted the daughter's application for summary judgment and dismissed Michelle's claim. Now, this case really highlights that a claimant must be able to demonstrate financial need, and we've been banging on about this whole time. But Nick, what are your key takeaways from this case? And would it have made a difference if the state was worth more? So if there's more money there to play with, there's more money in the pot, could the court look and go, yeah, maybe she's got prospect of success in this case?
If this estate was at the very least worth more than she had, I think the prospect that it would have been dismissed summarily would have been lower. I think that if this was a $10 million estate, a judge might have had more sympathy for the idea that the estate could have provided a lump sum to her to further protect her from the possibility of something going wrong in her life. It's hard to justify in legislation, but I do think that that's open. And at the very least, it might have been to survive summary dismissal. I think the key takeaways are that financial need is and remains paramount in these claims. It can be an awkward conversation, I'm sure, early days with clients to say, spill the beans, tell me everything you've got. I want to know investment properties, superannuation, what kind of car you have. You need to find out about their partner sometimes.
Yes.
If they've got a partner, what are their partner's assets? That can be awkward and time-consuming, and clients can be reluctant to disclose it. But if they don't tell you at the start what they've got, they could be in for a rude shock partway through expensive litigation. I think the other big takeaway out of this case is that summary judgment as a tool to get rid of these claims is alive and well. Traditionally, historically, not many claims like this would be disposed of by summary judgment. Discretionary claims are hard to get rid of through summary judgment because there's a lot of discretion, and a judge can't say at the early stage, well, this has got no real prospect. But this case, and there are other recent cases, shows that in the right case, it can be gotten rid of. So if a bad claim without financial need gets brought, this is a good example of what might happen to it.
Last point I want to ask, last question, not even a point. Do we think it's fair? We know what the law says, but do you feel it's fair? She's a wife for 20 years. She cared for him. Because she's got a lot of money, she didn't get any provision. Is it fair?
I think it is. I think that when you're in a relationship with someone who's unwell and you're caring for them, you're doing it out of love. You're not doing it because you're getting compensated. And if you think you're doing it because you're getting compensated, well, maybe you don't deserve the compensation in the first place. So I think the outcome is fair. It would have been better if she'd been able to discuss with her partner and have a will in place that reflected her expectations. But I don't think she's someone for whom there needs to be provision. What do you think, Linda?
Oh, I was going to let you have the last word. Look, I agree with you. She's worth over $6 million. And we're talking also about a blended family situation. He obviously wanted to provide for his daughter as well from a previous relationship. But I do understand and I empathise that it came from a place of hurt, that someone you loved and cared for, she wasn't mentioned in the will. So I think that's what it was. I think if he left her something, perhaps she might have been in this position. And I really do think that so many of these claims are brought from a place of hurt, rightly or wrongly.
I often say to people that in most estate claims, whether it's Part 4 or will validity, could be avoided if people talked when they were alive about what they were planning to do when they were dead. That's not a conversation that we in Australia are very comfortable having, but it's a conversation that would avoid a lot of litigation and a lot of legal fees.
Yeah, absolutely. Thank you, Nick. Well, that's today's spill. Thanks for sipping along with us on Wilson Spills. Join us next time for another cocktail, another case, and another story to unpack. Cheers, Nick. Thank you.
Cheers.